You just got the call, Goldman Sachs. $500,000 base salary, your heart's racing, you're already mentally spending it. But here's what they won't tell you in the offer letter. If you're on an H-1B visa, your real net number is substantially lower. We're talking $50,000 to $80,000 annually in direct and indirect costs that silently erode your compensation. In the next 9 minutes, I'm going to break down every single hidden cost, from USCIS filing fees to attorney costs to the opportunity costs of visa processing delays, and show you exactly why ignoring these numbers could cost your retirement nearly $600,000 in compound growth. Let's start with the direct costs, because these are the easiest to quantify and often the most surprising to candidates who have never gone through the H-1B process before. First, USCIS filing fees, the baseline cost. When your employer files your H-1B petition, they're not just submitting paperwork. They're paying the U.S. Citizenship and Immigration Services for the privilege. According to the official USCIS fee schedule updated for 2024, here's what gets charged. The I-129 petition filing fee is $460. That's the baseline, but then it gets more expensive. If your employer is filing for an H-1B dependent on specialty occupation status, they pay an additional $500 fraud prevention and detection fee. So we're already at $960 just for the basic petition. But wait, there's more. If your employer has more than 50 employees and more than 50% of their workforce is on H-1B or L-1 visas, which applies to many tech and finance companies, they pay an additional $4,000 H-1B dependent fee per visa. Goldman Sachs, for instance, sponsors hundreds of H-1B visas annually and definitely crosses this threshold. That brings the total to approximately $5,960 per H-1B petition filed. Here's the critical question: who pays for this? Officially, employers can pay these fees. But in practice, especially in competitive hiring scenarios, employers will negotiate whether costs are shared. Some companies explicitly state they cover all visa costs. Others shift partial costs to employees. According to a 2023 survey by the National Foundation for American Policy, approximately 35% of H-1B visa costs are partially or fully borne by employees. Let's assume Goldman offers to cover it entirely, best case scenario. That's still $5,960 taken out of the company's budget for your sponsorship, money that could have gone to your base salary or bonus. You should absolutely factor this into your real compensation number. But the USCIS fees are just the beginning. Second, immigration attorney costs, the often overlooked expense. Most companies don't process H-1B visas in-house. They hire immigration law firms. These firms typically charge between $5,000 and $15,000 per H-1B case, depending on complexity and location. In major financial centers like New York, where Goldman Sachs has significant operations, you're looking at the higher end of that range. Why does it cost so much? Because immigration law is complex. The attorney needs to 1. Conduct a prevailing wage determination, ensuring your salary meets the Department of Labor's requirements for your position in your geographic area. For $500K salary at Goldman in New York, this is typically straightforward, but the analysis still costs time and expertise. 2. Prepare the Labor Condition Application (LCA) and file it with the Department of Labor. This involves detailed documentation of your job description, required qualifications, and the company's recruitment efforts. 3. Prepare the I-129 petition itself, which is a detailed document that must clearly articulate your qualifications and the specific duties of your position. 4. Handle correspondence with USCIS, address any requests for evidence RFE, and manage the entire approval process. 5. If needed, manage premium processing USCIS Form I-907, which costs an additional $2,500 but speeds up approval from months to approximately 15 calendar days. For high-salary position at Goldman, premium processing is almost always recommended. Why? Because you can't start work until you have H-1B approval. If approval takes 4-6 months normal processing timeline and your start date is set, you either delay your start or work illegally, neither is acceptable. So that $2,500 is practically mandatory. Total attorney costs, approximately $12,500, $15,000 per visa sponsorship. Now again, companies often absorb these costs. But here's the financial reality. These legal fees are a real expense in the sponsorship equation. When negotiating your compensation, a company that covers $15,000 in attorney fees has effectively paid you $15,000 that doesn't show up on your offer letter. Third, annual renewals and recurrent costs. H-1B visas are typically valid for 3 years, renewable for another 3, but you don't just file once and forget it. H-1B status requires ongoing compliance and periodic filings. If you change jobs even within the same company from one department to another, your H-1B typically needs to be amended. That's another attorney fee, $2,000, $5,000. If you move to a different geographic area, the prevailing wage determination changes, which can trigger another amendment. Every 3 years when your H-1B expires, you need to renew it. That's the full USCIS filing fee process again, approximately $5,960 for a second or third renewal. Over a 6-year H-1B period, 2 3-year terms. Assuming you don't change positions, you're looking at year 1, $5 960 USCIS plus $15,000 attorney plus $2 500 premium processing equals $23 460 years 2-3 $0 just status maintenance year 4 $5 960 USCIS plus $12,000 attorney for renewal plus $2 500 premium processing equals $20 460 years 5-6 $0 annualized over 6 years approximately $6 820 per year in direct costs. Fourth, the hidden cost processing delays and opportunity costs. Here's where the math gets really interesting, and frankly, where most people underestimate the true impact. H-1B visa processing doesn't happen overnight. Here's the timeline. 1. Your employer files the H-1B petition. Must be done by April 1 of the fiscal year for October 1 start date. 2. USCIS receives and reviews the petition 2-4 months for standard processing, 15 days for premium processing. 3. Assuming approval, you still need to complete consular processing or adjustment of status, depending on your situation. 4. Total timeline, 3-6 months from filing to actual work authorization. Now, imagine this scenario. You're a candidate being recruited for Goldman Sachs in January. The H-1B petition for October 1 start has already been filed. It was filed in early April of the prior year. You're in a good position. But what if you're being recruited in June for a different team that needs immediate staffing? Your employer might need to wait until the next H-1B fiscal year, October 1 of the following year, to formally bring you on. That's a 4-month delay. During those 4 months, are you working, possibly under a different visa status like OPT if you're F-1 eligible or an L-1 if you were transferred from another office? But you're not in your permanent role, which means you may not vest in equity grants on schedule, you may miss performance evaluation cycles, and bonus opportunities, you may not receive the full benefits of your employment agreement. Let's quantify this. If your total compensation is $500K, including approximately $200K in annual bonus and $150K in equity, a 4-month delay in official start could cost. Lost bonus, $67,000 4/12 of $200K delayed equity vesting. If you were supposed to vest $150K in year 1 on a 4-year schedule, $37,500/year, a 4-month delay could push your vesting schedule back by 4 months across all 4 years, ultimately costing you approximately $50,000 in present value, accounting for the time value of money and the fact that earlier vesting is more valuable. Total opportunity cost of processing delay, approximately $117,000 for a single visa sponsorship delay. Over a career, if you change jobs twice, each requiring visa sponsorship, and experience delays both times, $234,000 in opportunity costs. Fifth, the long-term compound effect. Here's the scenario that should really worry you. Let's say over your 15-year career, you're on H-1B visas for approximately 8 years, 2 employers, 2 sponsorships with 4 years each. Direct costs, 8 years times $6 820/year equals $54,560 opportunity costs from delays, $234,000 as calculated above, and total explicit cost, $288,560. But the real damage is compound growth. If you'd invested that $54,560 in direct costs alone in an S&P 500 index fund, historical average return, 10% annually over 15 years at an average time in the market of 5 years, accounting for when costs were incurred, that would grow to approximately $54,560 times 1, 10, 5 equals approximately $107,000. Now add the opportunity costs. If you'd been able to invest the $234,000 in opportunity costs by not experiencing those delays, and you'd receive that money in year 5 on average over the remaining 10 years, $234,000 times 1, 10 equals approximately $607,000 total compound cost, approximately $714,000 in lost retirement wealth. That's not a rounding error. That's nearly $715,000 that you won't have in retirement because of visa sponsorship delays and costs. The Goldman specific calculation. Let's be concrete about your $500K offer. Base salary, $500,000 direct visa costs, amortized, $6 820 effective salary, $493 180 effective reduction, 36%. But that assumes no delays. If you experience a 4-month processing delay as described above, effective salary accounting for opportunity cost amortized over 3 years, $500,000, $6 820 $39,000 equals $454 180 effective reduction, 16%, and that's before income taxes, which will take another 35-40% in New York, federal plus state plus local combined. Final takeaway when you're evaluating that $500K offer from Goldman Sachs, ask 3 questions. 1. Will the company cover all visa sponsorship costs?